Welcome to HR Shield's training presentation on triple threat, which is the interaction between the ADA, FMLA, and workers' compensation, and the impact on your business. There are several reasons why it's important to understand the interplay of these three laws. Number one is that the majority of the unscheduled absences and scheduled absences that you will get in your business are related generally to either the illness of the actual employee or illnesses of their family members. One, both, or all three of these laws may be involved in those absences. Number two, violations of these laws could result in lost wages, back pay, reinstatement, retroactive benefits, compensatory damages, and punitive damages. And finally, other than legal responsibilities, employers have a moral and ethical responsibility to ensure that their employees are receiving the benefits and protection that these laws provide to them. So what we're going to discuss today is we're going to start off talking about employee coverage. Depending on the size of your organization, one, two, or all three of these laws may apply to you. Only 13 states require more than one employee as a threshold for workers' compensation coverage requirements. In the state of Florida, for example, you need to have a minimum of 4 employees in order to be required to cover them with workers' compensation. The areas of interplay between ADA, which is the Americans with Disabilities Act, FMLA, which is the Family Medical Leave Act, and workers' compensation are that employers need to consider when they're managing employee absenteeism. ADA applies to all employers who have 15 or more employees for more than 20 weeks during the current or preceding calendar year. FMLA is 50 or more employees within a 75-mile radius, and workers' compensation, again, state laws govern. If you're unsure as to whatever the threshold is for workers' compensation in your state, please contact your HR Shield advisor and they will let you know how many employees is a threshold for you to cover them with workers' compensation. So as you can see, workers' compensation, state laws govern. For ADA, at least 15 or more employees for 20 weeks during the current or preceding calendar year. And for FMLA, 50 or more employees within a 75-mile radius. So it's very possible that all three of these laws could actually affect your business. So let's talk about how the employees are actually eligible for any of these three. For ADA, an employee or applicant who is disabled as defined by the ADA is qualified for the position and can perform the essential functions of the position with or without a reasonable accommodation are eligible for coverages under the ADA. For FMLA, an employee who has worked at least 12 months and 1,250 hours prior to the start of leave and who works at a work site where there are at least 50 or more employees within a 75-mile radius. And for workers' compensation, an employee who has an injury arising out of or in the course of employment. So these are the three instances of how an employee is eligible for any of these three. The length of leave. So if they are actually eligible for any of these three, how much time do they get under these laws? For ADA, there's no specific limit for the amount of leave that an employee can be provided as a reasonable accommodation that does not create an undue hardship on the employer. And we'll talk about undue hardship later on in the presentation. For FMLA, the employer is granted 12 weeks in the 12-month period beginning from the date that the employee first uses their FMLA. And later in the presentation, we'll talk on how they can take those 12 weeks of time. And for workers' compensation, there is no specific time limit for the amount of leave an injured employee may have. So what type of medical documentation is required by an employee if they are indeed eligible? First, for ADA, only medical examinations or inquiries regarding an employee's disability that are actually job-related and are limited to determining whether or not they can actually perform their position. And that will help you decide whether an accommodation is needed and would be effective. So the only time you can ask for a medical examination is in the case of, can this person actually do their position? For FMLA, there is a medical certification that is required for the leave, and you have to be able to look at it and certify whether or not it falls under FMLA guidelines, which we'll speak about later. And it's requested in the Department of Labor medical certification form, is the form that you'll actually use that the employee will take to their physician. For workers' compensation, the only medical information that can be collected for workers' comp is those that pertain directly to the injury that they sustained on the job. Now we're going to speak about restricted or light duty and whether or not it's required as part of these three laws. For ADA, you're required to offer a restricted or light duty position if it does not create an undue hardship on the employer. And let me explain what undue hardship means. Let's say, for instance, you have an employee who has been working for your company for 10 years on a machine that requires repetitive hand motions. And during the course of their employment with your organization, they have gotten a disability in which they have carpal tunnel syndrome or something along those lines, which is that repetitive injury has caused them. An undue hardship would be if you were required to replace $1 million machine in order to accommodate the hand motions of that employee. That would be considered an undue hardship because, of course, spending $1 million on a machine could very possibly bankrupt your organization and you'd be unable to continue business. However, if simply changing where they were on the line or putting them on a light duty position or perhaps offering them a clerical role or offering them some other type of role that wouldn't cause you any undue hardship is required to be offered by the ADA. With FMLA, you cannot require someone who's out on FMLA leave to return to restricted or light duty. If you have it, you can certainly offer it to the employee, and if they choose to accept it and are released by their physician to do so, they can come in and do a light duty, but you can't require them to come back to your company and work a light duty or restricted position. For workers' compensation, it's not required, but the guidelines state that you should offer a light duty or restricted duty position to someone out on a workers' compensation injury if something is available within the company. So if the employee is eligible, they are in fact fall under the guidelines to be eligible for any of these particular types of leave. They've brought in the medical certification necessary for you to approve the leave, and they have taken it, and their time is up, and they are wanting to return back to work, or they've been released to do so. Are you required to ask for a fitness to return to work? For ADA, it is permitted as long as the medical examination and the inquiry is actually job-related and it's necessary to determine whether or not that employee can actually perform the essential functions of the job. And going back to the original example that we gave earlier with the employee who's doing the repetitive motion on the machine, you need to be sure that the doctor is in fact stating that that person can return to that type of duty, performing that particular position without any restrictions. And this is why it's very important to have very clear job descriptions related to all the positions within your company, because when they do return to work, it needs to be very clear on what's expected and whether or not they can return to that same position. For FMLA, the only time you can require a fitness to return to work is if it's part of your actual policy or practice that requires employees who have been on a similar type of leave of absence also to return with a fitness to return. So what that means is if you have a regular policy that states if anybody leaves on any type of leave, whether it's FMLA related or not, that when they return to work that you're requiring a doctor's note stating that they can indeed return to performing the duties of their position. But it has to be part of a regular policy or practice of your organization, and your employees need to have had access to that or be familiar that that's part of your policy in order to require a fitness to return to work. And for workers' compensation, it is typically required that they get a fitness to return to work because they have, of course, injured themselves while in the course of duty in your organization. So what type of benefits do your employees get while they're actually out on any of these types of leave? For ADA, there's no specific requirements, but you certainly can't discriminate against employees that work for your organization, and you have to provide them the same benefits as you would those who are on a non-ADA leave of absence. For example, if you have someone who is out on FMLA and you're providing them continued health benefits as is required by law, you need to provide that same, you can't discriminate against someone who's out on ADA. So it's very important that you are clear across the board and that you treat everyone the same as those who are non-ADA leave of absences. For FMLA, you must continue health coverage at the same level as prior to leave. It's important in your policies to include how those monies will be recouped because, of course, if someone's out on FMLA, it's very likely they are not earning any income. And if this is the case, they're unable to make their premium payments. You need to determine whether or not you'll be billing that person while they're on FMLA or whether you choose to recoup those funds when they return to work. And it needs to be a part of your regular policy so that your employee is fully aware of what the circumstances are and how they need to pay back those premiums. For workers' compensation, it's not required that you continue their health insurance unless it runs concurrently with FMLA leave. So if someone goes out on leave and is returning to work and brings back a fitness for duty, do you have to give them the same position, or what is the role that you have in putting them back into their position? For ADA, you're required to reinstate them to their previous job unless doing so would create an undue hardship on the employer. We spoke about the undue hardship. Certainly understand that if you do decide to not reinstate an employee because you think it would be an undue hardship on you, you need to make sure that you can prove that in a court of law. Because if that employee does decide to take you to court and say that you could have reinstated them and it wasn't an undue hardship, you have to show that it indeed was. For FMLA, you're required to put that individual in the same or equivalent job. There is no undue hardship exception. If for some reason during the 12-week time that the employee was out, their position was eliminated or you had a restructuring and it's no longer available to them, you need to be sure that you're putting them in the same type of role or an equivalent job in which they had the same responsibilities. If they managed people when they left, they need to come back into a management role when they return. You have to be very cautious to put them in the same or equivalent position. For workers' compensation, there are no reinstatement rights except for retaliatory charges. And what that means is if you let someone go while they're on a workers' compensation leave and do not return them to a position and they say that you discharged them as a form of retaliation, you need to be able to prove that that indeed was not the case. So now that we've spoken about the three different types of the triple threat, which are ADA, FMLA, and workers' compensation, we're going to go into a little bit more in depth about FMLA. Again, this only applies to organizations who have 50 or more employees within a 75-mile radius. So let's go ahead and start to talk about FMLA. FMLA is the right to be absent from the workplace for up to 12 work weeks of unpaid leave for the following events: for the birth of a child, for the adoption of a child, for the care for certain family members with serious health conditions, for an employee's own serious health condition, and for something called a qualifying exigency. And what a qualifying exigency is, it's for families of members of the National Guard and Reserves when covered military members are on active duty or called to active duty in support of a contingency operation. This leave may commence as soon as the individual receives a call-up notice. And a qualifying exigency must be one of the following: either short notice deployment, military events or activities, child care and school activities, financial and legal arrangements, counseling, rest and recuperation, or post-deployment activities. There may be additional activities that do arise out of active duty, but they need to be something that the company and employee agree, including agreement on the timing and the duration of the leave. So that is the definition of qualifying exigency and what falls under that particular type of leave. Family military leave is a little bit different than FMLA. It allows eligible employees to take 12 weeks of leave due to a qualifying exigency arising out of a call to active duty. And eligible employees may take 26 weeks of leave to care for a family member or who is injured or ill as a result of service in the military. So this is to care for a spouse, son, daughter, parent, or next of kin covered service member with a serious illness or injury incurred in the line of duty or active duty. Next of kin is defined as the closest blood relative of the injured or recovering service member. And this type of FML leave is also known as military caregiver leave or covered service member leave. So as you can see, it's a little bit different than FMLA, as it does provide 26 weeks of leave as opposed to the 12 weeks of leave for qualified exigency or for traditional FMLA. So what benefits does FMLA provide to an employee? The first is a continuation of their health care benefits while they are out on leave. The second is a right to return to the same or equivalent position after they return from FMLA leave. Third is the right to use accrued paid leave during FMLA protected leave if taken according to policy. Quite often, companies will put in their FMLA policy that they would like for the employees to use their use their PTO or vacation time as soon as they take their FMLA leave. If you want this to be a part of your policy, it's very important that you add it and make sure the employee is aware that when they take their FMLA, that you will apply any unused PTO or vacation time to their FMLA leave. And also, no discipline for FMLA-related absences. If an employee is absent due to FMLA and you have an absenteeism policy that states so many occurrences will result in some type of disciplinary action, their FMLA-related policies cannot be held against them for that particular type of discipline. There is no retaliation for exercising their FMLA rights. and no consideration of the use of FMLA leave in making employment decisions. In other words, if you're getting ready to promote someone from within your department and you're starting to look at some possible candidates to promote into a management type of role, you can't use the FMLA leave or the absenteeism related to that as part of the employment decision as to whether or not to consider that person for a management role. You also cannot discriminate from prospective employees for FMLA use. So as an example, just to clarify that, if an individual has worked for you in the past, say for 2 years, and leaves your organization and then comes back 6 months later, and they were a great employee for you before, and you happen to notice when they come back in for their interview that they're pregnant, you can't make a decision not to hire that individual for a prospective position with your company based on the fact that they are likely eligible or are eligible for FMLA, and you do expect that they'll be using it at any time in the future. So you need to be cautious that you do not discriminate against applicants for that probability. And also, you cannot make any attempts to discourage an employee from actually using FMLA. If they're eligible for it, they have the right to use it. So now we'll speak about, again, who is eligible for FMLA. The eligible employees need to meet 2 requirements within your company. First, they have to have worked for your company for 1 year, and this time does not have to be consecutive time. So for instance, in the example I gave earlier of the employee who returns to your organization after being gone for 6 months, but had worked for your company for 2 years prior and has been rehired, you have to count the previous time as part of their 1 year of service. This also applies to temporary employees. If you have temporary employees whom you have taken on to a permanent employee basis and have worked for you prior to that time as a temp, you need to count that time they were with the temporary agency working for your company as part of their 1 year and 1,250 hours. So please keep that in mind. If you have any questions regarding whether an employee is eligible for FMLA, you would need to check with either your payroll company or your HR advisor. So if an employee is eligible for FMLA, how much time does this individual get to use? Full-time employees of your company can use 12 work weeks, which is equivalent to 480 hours. Part-time employees can use 12 work weeks, which is equal to 360 hours. And how can they take this leave? An employee can either take a reduced leave schedule, meaning you're going to reduce the number of regularly scheduled hours they work either per day or per week. They can take the time in block leave, which covers one continuous absence made of consecutive days, which generally falls most commonly under maternity leave or birth or adoption, something along those lines. They can also take something called intermittent leave, which is a little bit more difficult to track because it includes multiple episodic absences for the same qualifying event. An employee is entitled to intermittent leave for a serious health condition only when it's medically necessary to take the leave in this way. And an example would be an employee that you have who is required to get certain treatments, possibly once, twice, 3 times a week. Perhaps they have to have regular doctor's appointments in order to seek the care for, such as examples would be dialysis or radiation or chemotherapy type of treatments. So these are multiple episodic absences for the same qualifying event. And how you would track the time and intermittent leave can be a little difficult. You have to determine in your policy how you're going to track them. Most companies will do it or can do it in the smallest increment that their time clock allows. So if your time clock is on a 15-minute increment, someone could feasibly take 15 minutes of time that could apply towards their 12 weeks of FMLA. What most companies generally do is round up to the full hour. But again, it's completely up to you how you set up your policy. Again, if you have questions regarding policy setup or you don't have a policy currently in place, certainly check with your employment labor law attorney or check with your HR advisor on helping you create this policy. So who can take leave? Well, the person can take leave for themselves if they have their own serious injury or illness. They can take it for their spouse, biological parent, or son or daughter, and that qualifies as biological, adopted, step, or legal ward of. And what is a serious health condition? There are 6 types of serious health conditions which an employee can take leave. The first of which is an overnight hospital stay. The second is over a 3-day incapacity plus treatment. The third is pregnancy. The fourth is a chronic condition. The fifth is permanent or long-term incapacity. And the 6th is multiple treatment. Ordinary illnesses do not qualify for FMLA. Examples of these would be a common cold, flu, earaches, upset stomach, headaches, or routine dental care. Substance abuse is covered only when the employee is seeking treatment and not just impaired by their usage. To be eligible for FMLA, an employee must have a condition that makes him or her unable to perform the essentials of their job. So how does this employee notify you that they actually need the time? The employee does not have to mention to you that it's FMLA in order to be entitled by its protection. You have to be able to notice that it is a serious health condition that they are qualified. We'll talk a little bit later about how you do that. An employee must present facts that indicate that it's potential FMLA protection. Verbal notification is sufficient. If someone calls you and verbally notifies you that it is an FMLA-related absence, and you do identify that it is, you do not have to wait for written confirmation in order for it to be sufficient for FMLA notice. The employer is required to make follow-up inquiries to determine if FMLA protection is required. So how do they notify you? They must provide FMLA notice in a timely manner. They must provide documentation per condition. And an example when we say per condition is quite often there could be a case where someone submits for FMLA with the intention of using for pregnancy leave. So they know that in 6 weeks when they have their baby that they're going to take up to 12 weeks of leave. But during the time of their pregnancy, they also discover that they are suffering from gestational diabetes, which is diabetes during the term of their pregnancy. If that is the case, they would need a separate documentation from their physician indicating that they would also need intermittent time in order to see to the gestational diabetes and the care for such a condition. Failure to provide any notice in a timely fashion could result in a denial of FMLA. So how do we know if it's FMLA eligible? Some questions that you can ask is, first of all, has the employee been out for 3 or more days? Secondly, are the absences related to a health problem or illness of the employee or a family member? If the answers are yes, you need to notify either your FMLA administrator or your HR department or HR advisor so that they can reach out to the employee and discuss their options. Timeliness is extremely important. As soon as you become aware that absences may be due to a serious health condition, the absences must be designated as FMLA qualifying as soon as possible following that absence. The supervisor must inform the HR officer if one of the following has occurred. The employee has been absent for 3 or more days. They've informed the supervisor that the need for absence is due to the illness of themselves or a family member, the care of a newborn child, to adopt or accept child for foster care. If there is an intermittent pattern of absenteeism, the supervisor has learned, either because the employee has volunteered the information or the supervisor has asked, they may be eligible for an FMLA qualifying reason. So it's very important that you keep those lines of communication open with your employee so you can ask the pertinent questions. There are certain employer actions prohibited by FMLA. These include making pre-hire inquiries regarding the need for FMLA leave, including periods of FMLA to disqualify employees for good attendance for awards or non-performance bonuses. It's extremely important that you hold FMLA absences separately. Asking employees for doctor's notes for each use of intermittent FMLA leave. This is very important. Even though an employee may be using intermittent leave, it may not be required that each time they use the intermittent leave that they're seeking the care of a physician. You cannot require a doctor's note for every absence related to intermittent FMLA leave. You cannot interfere with an employee's rights under FMLA. You cannot retaliate against an employee who files FMLA complaints. It's important to note that FMLA uses the same definition of employer as FLSA, and this includes any person acting directly or indirectly in the interest of an employer in relation to an employee. Consequently, the managers and officers may be individually liable for any violations of the requirement of FMLA. So even though you may not directly be this individual's manager, the supervisor, anyone who has directly or indirectly is acting in the interest of the employee could actually be in violation of requirements of FMLA. So what is the procedure? We're going to just kind of put it in a little synopsis for you here. The first of which is determining whether or not your employee is eligible. You start by determining, do I have 50 employees and do they work within a 75-mile radius of my organization? Then you need to determine if the employee themselves is eligible. Have they worked for your company for a year? And have they gotten 1,250 hours in the culmination of that year? Then you need to determine if the leave is actually FMLA qualifying, and those are those 6 serious health conditions that we spoke about earlier. If those are the case, then you need to start with the appropriate forms, which are available on HR Shield under the Forms Library. The first of which you can use if you choose is an FMLA leave request form. Many organizations actually give this form to the employees to fill out as a kind of precursor to the actual FMLA forms that are required by the Department of Labor. Once the employee has let you know, or you've determined it's FMLA leave, and you've determined that they are indeed eligible, there is a form called a Notice of Eligibility, which you must give the employee, letting them know that they are indeed eligible for the time. Secondly, you would give them a certification form, and this physician certification form is taken, the employee takes that with them to their doctor, and the doctor will fill that out, so that way you can review it, or your HR or FMLA administrator can review to determine if the serious health condition does indeed apply, and what type of leave, whether it be blocked, reduced leave, or intermittent time may apply. Finally, if you approve the FMLA and all the paperwork has been turned in a timely fashion, you then would give that employee something called a designation notice. And the designation notice just lets them know you are indeed eligible, you have indeed given us the proper paperwork, this is when your time begins, and this is how we will track that time. It's very important to have an FMLA leave tracker so that you can track the amount of time that the individual is using, whether it's block time or intermittent time. And then, of course, you need to prepare for the employee's return to work. As you continue to track their time, as it comes time for the end of that 12 weeks, we need to determine how we're going to integrate that employee back into their position and back into their job in terms of any additional trainings they may have missed or anything that they may have missed during that time that they haven't been in your organization. So, what are some common questions that you may get as you think about or determine FMLA? The first of which is, can you ask your employee why he or she is absent from work? Absolutely. The answer is, in fact, if you are required to ask under FMLA, the employee does not have to assert their FMLA rights. It's the supervisor's responsibility to recognize that an absence may be FMLA qualifying. An employee does not have to reveal their diagnosis, but they should give you a general reason for the absence. An employee who is approved for more than one condition must identify which approval the absent falls under. So that way you'd have 2 trackers for each absence and each issue. How do you know if an absence is FMLA qualifying? The FMLA covers absences for serious health conditions. Do not assume that an employee's absence is not serious. The definition of a serious health condition can include episodic absences and minor illnesses of more than 3 consecutive calendar days, including scheduled days off if the doctor certifies their inability to work on those days. For reference, the FMLA policy lists all types of absences that are FMLA qualifying. If you do not have an FMLA policy, it's highly recommended that you put one in place that identifies what these serious health conditions are. What do you do if you suspect that an absence does qualify? You should have a meeting with your employee in a private place and ask the employee if they or a family member may have a serious health condition. Again, it's important to determine whether or not these are FMLA qualifying, and you need to make sure that these conversations are held in private. You don't want to run the risk of violating the employee's rights and violating HIPAA by sharing any personal health information. Do you provide HR or your FMLA administrator with medical information that you receive? The answer is yes, absolutely. If you receive any medical information to support a serious health condition, it should be immediately forwarded to HR in a sealed envelope marked personal and confidential. Do not keep a copy. Your HR department will maintain all medical information in a confidential medical file, and based on that information provided, the Human Resources Office will determine whether to approve the leave or to notify the employee of their rights, duties, and responsibilities under FMLA. If you do not have HR on site, it's highly recommended that your manager or someone within your, like your CEO or CFO, have a locked department under lock and key where they can actually keep this medical information. And it's very important that no copies be kept on the general floor. Can you disapprove requests for FMLA if you feel that the absences are excessive? No, you cannot disapprove requests for FMLA qualifying leave. If you suspect there's abuse of FMLA privileges, you need to discuss the situation with either an HR representative or with your employment labor law attorney to determine that. You may decide to obtain medical information that's been updated or more recent, or schedule an independent medical examination. Again, it's according to policy, and you need to make sure that you receive the proper guidance in terms of that. And what do you need to do when an employee returns from FMLA leave? First, you must verify that the employee has been released to return to work based on the date of approval letter, and of course that they've come back with a fitness to return to work. And you must also inform your HR department so that the employee can be returned to the payroll if they were out on unpaid leave. So hopefully today we've been able to answer some questions for you about ADA, workers' compensation leave, and of course FMLA. How HR Shield can help you on a continuing basis, as you can see our how-to section under the in the website, and you can look for guides to FMLA, workers' compensation, and claims. You can also see our forms library that not only includes guides from the Department of Labor, but also all of the Department of Labor approved forms for FMLA. And you can also contact your dedicated HR advisor for additional guidance. It's important to remember that the information that we put in this presentation should not be construed as legal advice and is intended to be for informational purposes only. HR Shield maintains a staff of tenured advisors who can assist you in any way you may need, and we encourage you to use this service for all of your employment needs. Thank you.